Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
Good evening, folks. This is Omar Serrato with the Tilted Lawyer Podcast. And I don't know how many of you are going to show up this morning or this evening. For me, it's evening. For some of you, it's the morning. But we got an important case to talk about. So they've gone to jury in the trial for Megan. And, what did I just do? Sorry, folks. I accidentally just X'd out of my... Here we go. They are now deliberating. They've been deliberating for about 3 hours today in the Megan Boswell trial. And if you're unfamiliar with that case, I don't think you'd be unfamiliar with that case if you're clicking on this video. But if you are, we're going to go through a timeline of what this case is about. This case, in many ways, mirrors the Casey Anthony trial, in that there was an innocent child that went missing for reasons unknown. It was undetermined for a long time who could possibly be the suspect. Of course, you had your suspicions. There, in this case, as in the Anthony case, there was interrogations. There was the suspicion that somebody was lying, but there was not really much evidence to prove anything. After some time, a body was discovered, same as in the Casey Anthony case, and they rapidly moved to place Boswell under arrest. So she is on trial. They've completed the trial. Both sides, defense and prosecution, has rested. Jury got this case and deliberated for a few hours. And what are my impressions of the case? I could tell you just off top, I am not so confident that the prosecution is going to get a conviction in this case. I know what Megan Boswell looks like. I know what she looks like. I know what she seems to be. But at the end of the day, when all of this went down back in 2020, she was a 17-year-old single mother raising a 15-month-old child. And like many young women who are tasked with being a single parent at that age, she was in over her head. Do I think that she killed her child? No, I don't think that. I think that what likely happened was probably an accident. I think she tried to cover it up because she's dumb. You can make all the excuses you can for her in the world. You can make all the excuses you want, but there's really the question that we're trying to answer is whether or not she's guilty of murder or not. I know that there are strengths to the prosecution's case and what they have tried to present at trial. They said that, well, the child was found in a trash bag covered in or wrapped in aluminum foil. Her fingerprints were all over the trash bag and the aluminum foil that she was contained in, the child. According to the prosecutor, the trash bag was forcefully pushed down. It was compressed. Presence of Megan's fingerprints on those items, especially the foil, suggested that she directly handled baby Evelyn's body and the materials that were used to wrap her head. Where have you heard that kind of a story before? There was a Casey Anthony trial where they tried to point to the same DNA direct evidence tie-in. They failed in that case because of many different reasons that we're not going to get into today. But in the case of Boswell, it's undeniable. They got her fingerprints on there. You have the medical examiner that comes in to testify that Evelyn died of asphyxiation. You have a cause of death. Purposeful asphyxiation, or is it possible that Megan possibly rolled over her child as she slept and accidentally suffocated her? It's a thing. It happens. It happens more often than you care to imagine. They point to when Evelyn's remains were discovered on her father's property. They were found on a shed on a property that had belonged to her grandfather, Tommy Boswell. There was a TBI special agent, Brian Fragley, who described finding Evelyn's remains in what used to be Megan's former playhouse. This brown shed that was contained on a Muddy Creek, on the Muddy Creek property. The condition of Evelyn's body was especially difficult for the jury to hear. I heard that some of the jurors had a difficult time. Some were physically ill at having to view photographs and evidence of the condition of Evelyn's body. The aluminum foil that was found inside the trash can was wrapped around little Evelyn's head. The prosecutor had stated that you could still see the impression of the foil on Evelyn's face. There was a picture that showed the trash bag after Evelyn's body was removed, with basically the shape of Evelyn's head. It was still visible. The body was found inside of a blankets. The victim's head was found surrounded by aluminum foil. So there wasn't much mistake that somebody tried to hide Evelyn's body, and the fact that Megan's fingerprints were on the body suggests that it was probably her, probably beyond a reasonable doubt. Initially, Megan, as you could imagine, was not forthcoming with law enforcement. She said that Evelyn was with Ethan. That was later proven to be untrue. And then they tried to charge her with giving false information, resulting in a police investigation. Excuse me. There was a witness that came in and testified that the trash can was found at Muddy Creek. There was photos depicting the trash bag packed down in the can, maintaining the shape of the head. It was all bad. Those are the strengths, or some of the strengths of the prosecution's case. There was also the narrative. And where she got into trouble was, number one, when she was interrogated, she thought it'd be a real good idea if she had a lawyer. But for whatever reason, she kept on talking without a lawyer, thereby waiving her right to a lawyer, and proceeded to give like a dozen different stories about what possibly happened in this case, about what was her level of involvement. She gives multiple conflicting stories to law enforcement. That was brought up multiple times during trial. She appeared to have this lack of concern, exhibiting unusual behavior. There were people that testified that Megan, her behavior after Evelyn disappeared was rehearsed. She was faking it. She was trying to play the part of somebody that didn't know where her daughter was, but it was obvious. Audrey Gibbs, who was a friend of Megan's, had mentioned that there were times where Megan waited a long time to change Evelyn's diaper. She failed to buckle her into her car seat. She was struggling to raise this child on her own. I mean, she had help, sort of, kind of. But when you're a single parent and you're 17 years old, it's a little bit overwhelming. She was in over her head. I don't think that there's any doubts about that. After Evelyn was declared missing, the prosecution talked about Megan's actions after Evelyn disappeared, taking trips, moving in with a new boyfriend, trying to paint this picture that she had this weird indifference to the fact that her daughter had went missing. And where have we seen that playbook from prosecutors before? That's exactly what they said about Candace or Casey Anthony. It's like, oh, look at her. She's so concerned about her missing daughter. She's over here acting like a big whore out at dance clubs and going out with multiple guys and partying and doing drugs and alcohol and whatever. They just basically trying to paint her as a little slut who was finally freed of having to raise her daughter. And so therefore now she's living it up and living the life she always dreamed of. And whatever you think of Casey Anthony, whether you think she's guilty or innocent, since in like the decade or so, 15 years since that trial ended, multiple people have weighed in the fact that, look, people deal with grief in a number of different ways. It's not dispositive of a case to suggest that just because somebody's acting a certain way, they're definitely guilty or know something or are somehow responsible for the death of this missing person, in this case, baby Evelyn. So, just playing devil's advocate, let's just say that the indifference was simply a form of grief from a 17-year-old that had not yet developed the emotional wherewithal to cope with the extreme nature of losing a child. I don't know. I have no way to explain it any better than that. All I'm saying is it wasn't dispositive of guilt. That's all. They straight up tried it. They did it. They said Megan was living her best life while her child was upside down, decomposing in a trash can. I'm pretty sure that came in opening statements. Defense attorney Gene Scott acknowledged that some of Megan's actions during the time of the disappearance were probably disingenuous. They even acknowledged that she wasn't all that forthcoming. They said that there was evidence of planning. The jury saw evidence that Megan and Hunter Wood applied for an apartment. Megan said that Hunter did not want Evelyn to live with them. This is something the prosecution could have used to show motive, and that's what they tried to do. The application to live at the Overlook Apartments was dated back to January 4th of 2020. So they tried to suggest motive. This is their weaknesses. The weaknesses of their case is nothing to sneeze at. Number one, we don't have a definitive cause of death. We have a death by asphyxiation. There's 100 different ways you could die while asphyxiating that don't involve death at the hands of your mother. And again, indeed, Gene Scott argues that the state had not proven a cause of death. Were they required to prove a cause of death? No. But it's problematic to assert that she's responsible for the death, and we can't even pin down a cause of death that would suggest that we know who did it or what happened. She's guilty of a lot of things, but according to her defense team, she wasn't guilty of that. There was medical testimony that while the medical examiners testified that the cause of death was asphyxiation, on cross-examination, they started to introduce potential alternative theories because they could not pin down a cause of death. A defense suggested that the possibility of medical conditions, other factors, might have caused Evelyn to die suddenly of natural causes. SIDS was talked about at trial. The prosecution on their rebuttal countered by asking how many of those alternate causes ends with a baby in a trash can, which was a fair point. But if you have a client who's 17 years old, in over her head to begin with, and she's playing the I was just so scared I didn't know what to do card, it doesn't make her guilty of murder because she tried to hide the death of her child because she didn't have the mental fortitude or the intellectual wherewithal to alert the authorities like right away. Maybe she was afraid. Maybe she thought she was going to get in trouble. Maybe a lot of things. Doesn't make her dispositively guilty of murder. No, it does not. Which is the point. Folks, give me 30 seconds. I got to fix something. Apologies. I'm back. The defense, they did try to introduce some alternate theories and suspects. They mentioned Hunter Wood. They suggested that Megan's ex-boyfriend might have been involved in Evelyn's death. He had access to the property where the body was found. He noted that the investigation seemed to focus almost exclusively on Megan. Maybe we're jumping to conclusions a little bit. There was much investigation into Hunter, third-party culpability evidence. The defense raised the possibility that Wood placed the baby's body at the location where it was discovered. Problematic with that theory is his fingerprints weren't found on any of the trash bag foil evidence where Evelyn's body was discovered, was it? But, they threw that out there. The prosecution argued that Megan's actions and behavior, lying to law enforcement, the indifference, the strange behavior during Evelyn's disappearance was relevant to demonstrate that her indifference and lack of remorse, combined with other evidence, supported the charges against her. There's no reason to look at anybody else. They tried to do that, but that wasn't really a great rebuttal. I'm not sure how the prosecution is going to take that. There wasn't, of course, any eyewitnesses. That's a weakness for the prosecution. Nobody's there. There's not a person on earth that's going to be able to testify, save for Megan, and Megan didn't testify. What happened to that child? None. No eyewitnesses to the alleged murder. Prosecution had to construct its case based on available forensic evidence and circumstantial evidence, which you're kind of starting with reasonable doubt when you have to do that. Circumstantial cases, you could win. You could win those cases. The way that I've had it described to me when I was in law school is that circumstantial cases are combinations of threads that tie into one specific outcome. And neither one of them are going to lead you directly there, but if you get enough of them in your hand, then you have to come to some sort of conclusion, which is all these threads point to only one possible conclusion. That's the way you win a circumstantial case. With what was presented here, we don't have a cause of death. We have a manner of death. No eyewitness testimony. We have evidence of disposal of a body, but that's not proof that she was covering up a murder. It's proof that she was covering up a death, for sure. I don't think she's getting away with that one. But guilty of murder, I don't know. And we've seen it happen in recent memory, that these kinds of cases are ripe for reasonable doubts. And in the hands of a skillful defense attorney, you can paint a picture for a jury to suggest that maybe this 17-year-old little girl, who, by all accounts, when you talk to her, does not appear to be her biological age. She appears younger than 17, the way that she talks, her emotional states. I don't know what her intelligence level is, but she's unsophisticated for sure. She was raising a child by herself, as tends to happen when you have a teenage pregnancy. I'm sensitive to these kinds of cases because my mom had me when she was 16 years old. There's so many different ways that could have went. There is a universe out there, perhaps in a parallel universe somewhere out in the ether, where my mom decided to get an abortion, where my mom accidentally rolled over me when I was sleeping over the bed, where, maybe she accidentally fed me expired chicken breast that held salmonella and, death by salmonella poisoning. I don't know, man. I just know that I've lived that life as a child and watched my mom struggle from the age of 16 until, now she's grown, but it was rough growing up. And nothing was easy for my mom. She had to help, but there was nobody that was raising the kids for her. She was very much a single person while she was doing it, and she did the best that she could. Was she perfect? No. Was she better now? Yes. But she was a child. And now that I'm grown, I'm 44 years old, and I think back to those days, it's a marvel that I'm alive, honestly, because when I think back about, it's funny when you get older. I've always thought about my mom as being my mom. But now, as a 44-year-old man, my memories of her, she looks like a child, just like a baby. And I look at pictures of her, it's like, that's just a kid. That was my mom. Jesus, how poorly that could have went. I'm very fortunate to be here. Children that are born into that deck of cards are not safe. They're very fortunate to make it out alive, let alone have any chance of reasonably having a shot at making a life for themselves. And so here's this girl, Megan Boswell, and she is trying her best to raise this child, and she's overwhelmed. Diapers, and they cost so much money, and every 5 minutes they're crying and crying. I'm not even suggesting that she lost her temper at this child, but they say when you have a newborn baby, a 15-month-old baby, you should not have them in the bed with you. Now, this baby is 15 months old, I think. But if it's the case that she rolled over this kid, perhaps because she was exhausted, because she's been up for 22 hours, and she's trying her best, and she wakes up to find a dead body underneath her belly or something. I'm not sure how many of you listening to this show right now would have done the right thing, which is call 911 immediately. I'm sure it's probably somewhere in the 90%. But when you're faced with that situation, and you're a kid, and you don't got a lot of direction, and you don't got anybody helping you out, there is a world where you can see where a kid like that will make a really stupid decision and try to cover it up and try to act like everything is normal and just let things spiral out of control. I can see a world like that. I'm not by any means justifying what she did at all. I'm just saying that had I taken this case as a defense attorney, I think you got to start there. Who was she? Who is she? What path was she walking in this universe prior to everything happening? Let's take a look at this timeline. Before we even got to trial, let's go back to December of 2019. December of 2019, Evelyn, you know what? I'm going to share with you guys the timeline so you guys have something to look at while I'm doing my thing. I think I got to do it like this. Yeah. So this is the timeline. This is what I have. December 2019, Evelyn is last seen. Witnesses state that the last time Evelyn was seen alive was December 6th. It's about 6 years ago now, 5 years ago. Megan begins a new job at the Chicken Shack and meets Hunter Wood. Megan was apartment shopping with Evelyn on December 8th. On December 26th, Megan initially reports that this is the last day that Evelyn was seen. Late in December, according to the prosecution, Megan murdered Evelyn by suffocation, placed her in a trash can. The grand jurors alleged that Megan unlawfully mistreated Evelyn's corpse, failed to report her death. In January of 2020, family members become concerned about Evelyn's absence. It had been about a month. On January 9, Bailey Hawkins messages Megan, asked about a court date with Evelyn and where Evelyn was. Megan claims Evelyn was with Ethan Perry on January 19th. Megan was in Blowing Rock, North Carolina. In February of 2020, Megan continues to give these conflicting stories about Evelyn's whereabouts. February 18th, Megan reports Evelyn missing 2 months after the disappearance, and after her other family members had decided to report her missing first. States she had been missing since December. Investigators note that Megan could not show them where Evelyn was living, such as diapers or pack and play. Obviously, all of those things would have been strewn about the house, or there would have been evidence of use. So they knew. I think they knew right away. On February 19th, the TBI issued an Amber Alert for Evelyn. 40 to 50 FBI, TBI, and Sullivan County investigators and intelligence analysts are assigned to the case. If you could remember back then, 5 years ago, it was a story. I don't know if it like blew up, but it was a big story at the time that kind of got lost in the shuffle because of COVID. February 21st, Sheriff Jeff Cassidy reports that his office received conflicting reports about Evelyn's disappearance. On February 22nd, Evelyn's law is prompted in the Tennessee Senate, which asks lawmakers to pass legislation making it illegal for parents to wait longer than 72 hours. That's a pretty common sense rule, I would think. But I mean, if you're really thinking about it, you got a 15-year-old kid and you've gone 12 hours without knowing your child's whereabouts. Shouldn't that be grounds to alert authorities? And shouldn't the absence of notification lead to criminal negligence resulting in child abuse at the very least? I feel like there's already ways to charge her with stuff, even without that law, but I digress. On February 23rd, Megan Boswell makes a statement concerning her mom, Angela Boswell, allegedly having given Evelyn to another person. Oh, this is so mirroring the Casey Anthony case. On February 24th, Megan tells the media that her mom had taken Evelyn to Mendota, Virginia. On the 25th, Megan admits to Agent Brian Fraley that Evelyn was dead, and she also showed up at the sheriff's office concerned about getting her body spray back and forming a search party, as well as asking about tampering with evidence. She was all over the place. To say that Megan was probably riddled with anxiety and fear is an understatement. On March 6th of 2020, Evelyn's body is found on the Boswell property in a shed. The remains found in a trash can wrapped in aluminum foil and a blanket. Megan is arrested. On March 10th, the TBI issues its first report after receiving items to generate a DNA profile. August 19th, Megan is charged with 2 counts of felony murder. That is murder occurring within the commission of a felony. On July 1st, Evelyn's law goes into effect. Dr. Danica Polchan testifies that Evelyn's cause of death was asphyxia, rules it a homicide. On February 4th, they begin jury's selection. Trial starts on February 5th. And it culminates. They just did closing arguments. Matter of fact, today. They did closing arguments today. Oops, sorry. Apologize for hitting my mic. So that's how we got here. Let me go into, there we go. Before I get home ahead of myself. So in opening statements, this is what happens. The prosecution paints a picture of a mom who violently took her daughter's life. The defense is highlighting lack of concrete evidence, like that's awfully presumptuous. We have no idea how she got there. Look, you could assume all you want, but to suggest it was my client is suggesting too much. Obviously, ruminations about the presumption of innocence. The prosecution opening statement, they're trying to establish a narrative of intentional murder. They're emphasizing, inconsistent stories, changing stories. They give a description of Evelyn. They portray her as a bright, growing little girl whose life was tragically cut short by her mom. If I'm a prosecutor, there's really only one way to play this case. You have to make it impossible that any other person other than Megan was responsible for this. You have to, of course, do all the emotional things, but you have to somehow find a way to vilify Megan. And of course, I mean, their version of doing that was to turn her into this person that was indifferent and going and living her best life and wanting to find a new apartment and do all these other things and lying to the cops. And she wanted this all along. This was an intentional. This was not an accident. She did this on purpose. You have to find a way to make it as if she is a monster. And no matter how you slice the evidence that was presented, I just don't think they got there. I don't think they got there. Prosecution states that Megan was violently ripped away. They talk about a preventable tragedy. Prosecution frames Evelyn's death as a preventable tragedy, suggesting that Megan had choices. She could have given the child up for adoption. She could have given the child to her grandparents. She could have done any number of things, but what she chose to do was take the life of this innocent little girl so that she can go live her best life. They talk about conflicting stories. It's easy to explain that away if you're the defense team. They allege that Megan gives conflicting stories about Evelyn's whereabouts, highlighting inconsistencies to damage her credibility. Sure. But under the circumstances, when you have a 12-year-old, when you have a 15-year-old, when you have an 18-year-old, and they don't have any life experience, and they're still kind of very much in little kid mode, meaning their brain is not developed enough to know how to react when they're in trouble. What is the first thing they do? Most of the time, they're either abundantly truthful or they are abundantly lying. There's very few in between. And the fact that she was afraid, the fact that she was unsure how she was going to be perceived, the fact that perhaps she knew that this child was dead, she didn't want to be found guilty of murder, the fact that she maybe was thinking, am I going to go to prison for life? Am I going to get the death penalty? It stands to reason that this 17-year-old kid might have given conflicting stories to law enforcement, and she would have done that regardless of whether or not she was telling the truth or not, because they were looking at her like she was a murderer. It was a little bit intimidating. Now, I'm not saying I believe or I'm trying to defend her. I'm just saying it's very easy to spin as a defense attorney, a skilled defense attorney in trial, to try to explain away the inconsistencies in this case. If she was a 40-year-old hardened lady that knew better with a successful business and had been living a life of luxury built on her many sacrifices and achievements, who was very skilled in the arts and forms of communication, harder to make that argument. But when it's a 17-year-old kid that presents like she's 12, you can see why she might not be forthcoming in the face of extreme accusation. That is all. That's all. Indeed, the defense immediately tries to cast doubts. They did talk about her. What was the motive? What would have been the motive for Megan to murder her daughter? You don't have to prove a murder, or you don't have to prove a motive when it comes to these murder cases, but it helps. It sure does help to have one. And of course, the ready-made one is she's 17 and she's overwhelmed. She's in over her skis. That's enough motive for most. Not that it justifies murder, but it is a reason why she could have conceivably thought that maybe I'd be better off without my 15-month-old daughter. Maybe. Defense argues that the state's theory was full of reasonable doubt because they didn't know how Evelyn died and they couldn't prove it, emphasizing the uncertainties in the state's case. They did somewhat go into alternative explanations, but not really. Presumptions of murder, or presumption of innocence, and all of that. They did go into this distinction between lying versus murder. Just because Megan Boswell may have lied to the police or improperly disposed of the body does not mean that she murdered her child. The defense sought to separate these actions from the charge of first-degree murder, which is what you would do. That is what you would do. Oh, boy. Let me get that out. To be Flair, love that name, says common sense is not in high supply, and as high supply as one would think. I think the problem with a case like this, to be fair, is that common sense is not so obvious in a case like this. I mean, one would argue that, it's common sense that the 17-year-old would lie to the cops, regardless of whether or not she's guilty of murder. There are others that would say, look, common sense tells you, of course, she's guilty of murder. I don't think that there's enough threads there to make it obvious one way or the other. I really don't. When you have a case like that, there's a reason why it took 5 years to litigate this case. And I think it's because it's a difficult case to prove. And there's a lot of room for the defense to chew on when it comes to offering reasons for reasonable doubts. Casey Faye says the ME said there were no cases classified as rollover co-sleeping events at the age 11 Evelyn was. However, just because something isn't probable doesn't mean it's impossible. State did a very poor job. Agreed with that. That, was something that I had thought about. I mean, 15 months old is not a 3-month-old. 3-month-olds can't even roll over by themselves. You got to put them on their back and make sure that they're propped up so that they don't roll over to their side and accidentally suffocate themselves. 15 months old, at 15 months old, children are running around, jumping, climbing on jungle gyms, trampolines, and all these things. They probably weigh on average between 15 and 25 pounds. I don't know how much Megan weighed, but she didn't look like she could have been more than $130, $140. I'm really bad at, I have no idea how much she weighs, but rolling over on a kid and asphyxiating that way at 15 months old is a little harder to do than if they were an infant, for example. Point taken, for sure. Casey says that the state fails in providing solid evidence that nails down their theory, and that's the problem. What would your theory have been? You can't say that, she strangled her to death. There's no evidence of that. There's no strangulation marks. There's no if there were marks like that on Evelyn's body, they would have pointed to that and said, look, here's the evidence. This was not an accident. This was not an accidental rollover. This was a purposeful murder. That's what this was. This was a purposeful taking of the life of a young baby by an overwhelmed mother, but they didn't have that evidence. I don't know if it's a bad job on them because they couldn't present that evidence as much as it was the evidence didn't exist. I mean, they have to try this case. They couldn't just let it go. The evidence was what it was. And so my prediction is I don't think we're going to have a verdict on this case tomorrow. I think this is probably going to go to verdict on Friday. Maybe. But let's just gloss over what was presented. So on day one, they're beginning with logistical, procedural matters. They addressed the charges, which included dismissing count 18, amending count 19 to ensure accuracy and relevance to the evidence presented. The decision to dismiss was strategic, possibly because of evidentiary challenges, which makes a lot of sense in a case where you don't have a lot of smoking gun evidence. They gave their preliminary instructions to the jury, and then they give their opening statements. The prosecutor Amber Massengill characterizes Evelyn as a bright, glowing little girl, violently ripped away by her mother. She argues that Evelyn's death was a preventable tragedy and that Megan had given conflicting stories about Evelyn's whereabouts. They were going to demonstrate that Megan murdered her daughter by suffocation and placed her in a trash can. So right away, you're pigeonholing yourself into this suffocation theory. How are you going to prove that? How do you prove it? Gene Scott, as you should, acknowledges the tragic nature of the case, counters the state's narrative by asserting that the prosecution's theory was based on reasonable doubts, particularly regarding the cause of Evelyn's death. He suggested that Megan's actions, such as lying to the police, hiding Evelyn's remains, was not indicative of murder, but rather was symptomatic of a young girl that was in over her head and just had no sense of direction about where to go, or what to do, or what to say. Her actions, he said, weren't criminal when she hid Evelyn's remains. That can't be right. They were criminal, but I think it's trying to make the distinction between they were criminal, not murder. I think that's what I meant to write in my notes. They appeared to be focused on creating uncertainty, and that was kind of where you had to go with that. So their initial witness testimony begins by calling Special Agent Brian Fraley of the Tennessee Bureau of Investigation. He testifies about being called to assist in the investigation of Evelyn's disappearance. He explains the TBI's role in issuing Amber alerts, details the initial missing persons case. So they're trying to establish a timeline. There was a significant legal issue during the proceedings about the rule of completeness. There were legal arguments about the rule of completeness, which allows an adverse party to introduce additional parts of a statement to provide context and prevent misleading impressions. The judge decides to review the video interview of Megan before making a ruling, and they talked about that. That was pretty much day one. Just that one witness, some motions. That was it. On day two, the court addresses the evidentiary issue from day one, and they ruled that the entire video of Megan was going to be allowed based on fundamental fairness and case law. Brian Fraley continues to testify. He's cross-examined. He testifies that after a bread bag was removed, a white trash bag was opened to reveal a gray and white fleece blanket. Then he saw a leg. He confirmed that a black trash bag was not gently placed on top, but had been pushed down inside the trash can. The white trash bag was compressed to a degree that it created a vacuum when removed from the can. Fraley stated that the trash may have been moved to the front porch to remove the black bag. That was him. Tommy Boswell testifies, Megan's father, that Megan never came to his property with Hunter and Evelyn. He said the last time he saw Evelyn was on Thanksgiving. He confirmed that a camper was not there in 2020, but everything else was accurate. On cross-examination, Tommy stated he did not expect a child to be on his property. I'm pretty sure that he had consented to a full-on search of the property. So he was, I think, very early on absolved or exonerated of any suspicion of wrongdoing. He says he calls law enforcement to the yard barn to see if there was a clue. He worked with law enforcement to help them. He stated he hadn't been in the dollhouse in years. Testifies that his property is 10.9 acres. Dollhouse is like 700 feet from his mom's house. The prosecution did impeach Tommy about 2 felony convictions, aggravated assault, kidnapping. Defense objects. Judge allows prosecution to ask about the felony convictions. Fine, I guess. Judge states that because there was no confinement, the 10-year period is measured from the day of conviction. Whatever. So he's a guy testifying, and he's been convicted of crimes. That was that. After that, Austin Feller comes in to testify that he lived at the trailer park on Sugar Hollow Road in 2019 while working for Tommy and Sons Paving. And he lived there in exchange for doing free maintenance. That was about it. James Lewis gets up there to testify. He says, he was a DCS supervisor. He testified about his role as an investigator, explains the process of receiving and investigating reports. He received a referral on February 18th regarding a 15-month-old Evelyn Boswell, allegation of lack of water, food, shelter, supervision. Lewis Detective Hars went to a residence of Beulah Community Road to meet with Megan Boswell. He described photos he took at the residence, including a sippy cup. The bedroom, Megan reported staying in the Preston Wood memory box stuff. Testifying that he and Detective Hars went to Ethan Perry's home, didn't find Evelyn there, spoke of Ethan's parents, they met with Megan at the Sullivan County Sheriff's Office. Lewis reviewed the interview he and Detective Hars did with Megan, confirming it was a true and accurate description. The video was played in court showing Megan stating Ethan did not have the baby. In the interview, Megan said the last time she saw Evelyn would have been around 8 p.m. with the babysitter. Casey Saltz gets up to testify. Testified that Megan was a foster child to her parents, lived with them when she was pregnant with Evelyn. And after Evelyn was born, she testified, or while she identified Megan in the room, she worked at Premier Pediatrics, was there at the time when Megan gives birth to Evelyn. Bailey Hawkins gives testimony, was close friends with Megan and knew her from high school. She said she spent a lot of time with Megan and Evelyn during the first year of Evelyn's life. Stated that she never saw any signs of abuse or neglect. Stated she never saw any injuries on Evelyn or had concerns that she had not been fed or cared for. She testified that she learned Evelyn had been reported missing on Facebook and Megan had not told her anything about it. She did talk about messages with Megan on January 9th. They were shown to the jury. Hawkins asked when Megan's court date with Evelyn was. Megan said tomorrow. Hawkins asked where Evelyn was, and Megan said still with Eaton. Hawkins testified that she gets a room for Megan at the Econo Lodge on Airport Highway on February 22nd. Megan said she wanted to get away with everything going on. Hawkins didn't stay there with her. She just drops her off. So they spend basically day 1 and 2 trying to paint a timeline of Megan's behavior leading up to the discovery of her daughter in the trash can. On day 3, there was jury admonitions and instructions. Bailey she's continuing on the stand. She says, she continues testimony with Bailey, who was one of her close friends. She reiterates she never saw any signs of abuse, same stuff, and then she finishes. There were several other witnesses. There was a Stacy who gets ready to testify about law enforcement visiting her home to inquire about Evelyn. Said that police seemed to know that she was not Evelyn's babysitter due to her wife's physical condition. Michelle Gillum was the Sullivan County Sheriff's Office lieutenant who was a detective in the Criminal Investigations Division in February of 2020, testified that she worked child abuse and child sex crimes, was involved in collecting items, but was not involved in TBI lab testing. Stated that her interview with Megan on February 18th was a follow-up to an earlier interview. There was an additional detail regarding other witnesses, including Christopher Wilhoy. There was some evidence and exhibits. Finally, they introduced Exhibit 93. There was discussion regarding messages with the court, giving an instruction as to explaining what those messages, whether they're taken from Facebook or Instagram. Exhibit 93 is made offered for identification, but was not published to the jury. Exhibits 69, 77, 78, 79, 80, 81, and 82 were entered as full exhibits over the objection of the defense. There were arguments to I think they tried to dismiss the case at one point. That didn't really go anywhere. Oh, what did I just do? All right. On day 4, there was Steve Williams' testimony. He was previously employed by the Sullivan County Sheriff's Office, testifying that he assisted in the investigation, participating in interviewing Megan. Again, more of this. Megan came in and her behavior and what she said and the inconsistencies in her story, trying to paint this idea that Megan was a big liar and her behavior was odd and that kind of stuff. A lot more of the same. What we're not getting is any physical evidence. David Gratz comes on to testify. A former TBI agent provides a summation of his education. in previous employment, confirms that the TBI was requested to assist in the investigation by the Sullivan County Sheriff's Office and formally requests in writing the DA, General Barry Stalcup. He discusses a sketch of the scene at 543 Muddy Creek and photographs of outbuildings on the property. He testified about searching the shed and playhouse on the property. Tommy gave consent to search property that day. Is what he was trying to say. And just kind of more just general, his experience and impressions based on that investigation. It wasn't really anything that points definitively to guilt. We're not there yet. Not yet. Day 5, they're continuing with Gratz's testimony. They introduced 6 exhibits. There was Exhibit 6. It was a sketch of the scene of 543 Muddy Creek. Exhibit 7 was a photograph of an outbuilding. Exhibit 8 was a photograph of the outbuilding and the playhouse. Exhibit 9 was a photograph of the building or a shed showing Evelyn's belongings. Exhibit 10 was a photograph of the playhouse. Exhibit 198, a black trash bag recovered from the trash can. That was it. And then he was done. Lieutenant Price testifies that, he identified a great value water bottle that was recovered from the trash bags. And also identified a white tissue with some kind of stain that was recovered from inside of the trash bags, and that was it. A pretty lackluster day of testimony. So on day six, beginning of the day, the court addresses some issues that were raised previously regarding evidence. Judge stated that he almost had the second draft of the charge ready, and that it had been his habit over the last 10 years to define the words that have to be defined in a definition. There's some digital evidence. They had text messages between Megan and Hunter on February 19th. In those messages, Megan stated that she had no clue why Hunter was mad at her and that she had been waiting for her mom for hours. There was a social media analysis of her. There was an analysis of her social media blueprints or fingerprints that was presented, including a message from February 18th where she stated she couldn't bring Evelyn over because Ethan wouldn't let her pick her up, and she had court in the morning. There was finally some forensic testimony. There was a forensic biology report dated on March 25th, 2020, was presented as evidence, just indicating that forensic testing had been done on the black trash bag. There was a medical examiner who gives some testimony. Dr. Smith testified as to the cause and manner of death of Evelyn Boswell. Dr. Smith states the cause of death was homicidal violence. This was based on his autopsy findings, investigative summary, and law enforcement investigation. And then he makes this bombshell revelation that she might have still been alive when she was placed in the trash can, leading to what he described as positional asphyxiation. Essentially where she would drown via her lungs flooding. Dr. Mink discusses 19 exhibits, explains how they're related to the mechanisms of asphyxiation. I'm not going to go through all of the technical stuff with that. Just the main takeaway from that is he presents the possibility of possible manners of death, but offers nothing conclusive. And that was it. That was the close. That was the close of testimony. Jurors are given admonitions, and then they left for the day. And then day 7 was supposed to be closing arguments. Let's see. So during closing arguments, Megan Boswell, she promised in her opening statements that she was going to tell a tale. She was going to prove this idea that Megan purposefully premeditated, with malice aforethought, committed an act that ended the life of her daughter, Evelyn. She said she was going to prove that. She argues that Megan murdered her daughter by suffocating her and placing her in a trash can. How did she suffocate her? Was it through strangulation? Did she drown her in a bathtub? Did she, how did this happen? It was never identified in evidence, not through eyewitness testimony, not through any of the exhibits. She urges the jury to remember that statements made by attorneys are not evidence. They're intended to assist in understanding the evidence. She reminds jurors that they should rely on their common sense. The problem with that is it's not abundantly clear to me what common sense is supposed to lead me to. I did not see enough evidence in this case to point definitively to anything in this case. I don't know if this little girl accidentally, Mike Tyson's daughter, like 8 years ago, I don't remember when it would have been, maybe 2015, 2014, but she accidentally strangled herself on a cord that was attached to a treadmill and ended her life that way. It could have been something like that. We have no idea what happened. No idea. But she's asking the jury to rely on common sense. I don't understand. She emphasized that absolute certainty is not required for a guilty verdict, but rather the ability to let your mind rest easy. That is a mouthful. She points to fingerprint evidence on the trash can, asks the jury to recall the testimony of TBI agent Hoover about how the trash can was handled. She stresses that the medical examiners conclude that Evelyn died from asphyxiation. Massengill describes how aluminum foil found inside the trash can that was wrapped around baby Evelyn's head, the manner and how it was wrapped around her head, utter disregard for the life that was Evelyn. She stated that you could still see the impression of the foil, and she's going through for the whole emotional appeal. Look at this ugly thing that happened. How tragic. Somebody must pay for this. And I propose it should be her, as she points to Megan. And that was it. That was it. Was it as bad of a job as you could possibly do? No. It was by no means spectacular. On the strength of that presentation of evidence, am I confident that she's going to get a guilty verdict out of that? Not in a million years. It wouldn't surprise me if they came back and just found her guilty. Just hell with it. She must have done it because look, I mean, the trash bag evidence is incendiary for sure. I have seen the hearts and minds of jurors become inflamed by much less. The strongest piece of evidence that they presented in this case that suggested that Megan was involved was in the disposal materials that were found in the trash can, where they were forcefully pushed down there, where the imprints of the foil or the imprints of Evelyn's face was still there on the foil, and they demonstrated that in pictures. There's a part of that that's emotional plea, and the common sense part of that would be, why would Evelyn have done that if not but for she purposely murdered her and tried to cover her tracks? But that presupposes that it couldn't have been an accidental thing with having her do the exact same thing because she's 17 and dumb. 100% dumb. And there's a lot of other choice language that you could conjure up to describe that kind of behavior. But, it's not proof positive to me that we have evidence beyond a reasonable doubt that Megan purposefully did this. So the defense comes back on their closing arguments. And he suggested, obviously the state hadn't proven their case. Megan did not murder her daughter. He highlighted that the case was more about what Megan didn't do than what she did do. Scott reminds the jury that the case was about proof and evidence, not emotions or sympathy. Scott argues that the state hadn't proven a cause of death or that the death was an unlawful killing as opposed to an accident. He emphasized that if jurors had unanswered questions about any elements of the crimes charged, they must find reasonable doubt. And as I sifted through the evidence in this case, I had a mountain of reasonable doubt. I've been wrong before about these kinds of cases, about whether or not you're going to get a guilty verdict or not guilty verdict or whatnot. I'm just saying, in terms of trying to prove the guilt in a murder case, I struggle to remember a case where there was less evidence against a victim or not a victim, against a suspect of a crime than this one. I'm just trying to think. Their strongest evidence was really just the trash bag fingerprints and stuff. The fingerprint evidence on the trash bags that were used to conceal her little body. That's the evidence. That's the common sense tie-in that they want. Look, that is compelling evidence. It is powerful evidence. It is evidence that might inflame the ire of the jury. For sure it is. But do I have questions as a juror? Yeah. Especially a guy like me that has a pretty good idea about how dumb kids are. I'm not unique in that. All I'm suggesting is, look, a 17-year-old raising a kid. Ignore the part about what kind of parent she may or may not have been. I don't care about that. All I'm saying is, at 17 years old, the way that she came off in some of her interrogation footage, she just appeared a lot more childlike than you would expect of a well-adjusted, educated 17-year-old kid. That is my very subjective take on all of it. Based on my knowledge of what those kinds of people are like, and based on, is it plausible that Megan just freaked out and decided to, rather than alert authorities, rather than call family members upon discovering the accidental death of her daughter, just decides to cover it up because she's afraid of what's going to happen to her? Maybe she's not forthcoming with law enforcement because she's just dumb. And I don't really have to take the inquiry further than that. For me to take it further than that is to try to explain the meanderings of dumb thinking, which I can't do. Sometimes people just do dumb things. Yeah, that's a simplistic way of putting it, but it could be as simple as that. It could be an Occam's razor kind of explanation for why she would do such a stupid thing. What I don't have is a clear-cut murder. Oh, she was so overwhelmed. Yeah, lots of parents are overwhelmed. They don't kill their kids. Lots of 17-year-olds are overwhelmed. They don't kill their kids. Believe it or not, it is an extreme anomaly for an overwhelmed parent to go to the extreme measure of taking the life of their children, regardless of how much is joked about or talked about, or how many true crime cases that you follow. Walkaway Renee says, the prosecution was severely lacking, in my opinion. I was shocked they didn't offer Google searches, GPS data. Half the time they weren't even clear about what day or time they were questioning witnesses about. Yeah, that would have been helpful. I'm not even sure it would have created a stronger argument for them to make. I'm just saying that was a very weak showing in terms of what this case was and what it turned out to be. It's like 5 years for that. We've been litigating 5 years for that. On the one hand, you want to say that, wow, they had 5 years to prep for this case. On the other hand, if you got evidence, you don't need 5 months. Honestly, when I was at the DA's office, I would be handed a case the morning of. And they'd be like, hey, you're up, chief. Get in there and make it happen. It'd be like a DUI trial or something, or like some kind of a misdemeanor trial. If you got evidence and you're a trial attorney, you don't need 5 years to prepare for anything. The reason this was taking 5 years was because the prosecution was not prepared. You know, when I think about this case, how I might have defended the case, I'm not sure that I would have allowed the prosecution to get 5 years into this thing. 5 years is an awful long time to litigate. It's a double-edged sword. On the one hand, you want to, if you're the defense attorney, in some cases, when you know that the prosecution doesn't have much evidence, sometimes you want to race to trial, to not give the prosecution more time than they need to prepare for the case. Wouldn't it make sense? Look, you got a right to a speedy trial. You got a right to have a trial heard, within a certain time frame. We don't have to wait 5 years, 30 days, 28 days, or whatever standard would be, 6 weeks after whatever. But for it to have gone 5 years, I don't know if I agree with that strategy from the defense perspective, but from the prosecutor's perspective, the fact that they went 5 years just tells me that there really just was not smoking gun evidence. And it manifested when, after 5 years of preparation, that was the best that they could do. Walkway Renee says, and beyond that, they didn't question Megan's mother or offer any reason what, when, why her relationship with Hunter ended. And now he's just locked in a mental institution. I was confused. Yeah, that's pretty confusing. That's pretty confusing. And it lends itself to a narrative that the defense could use, which is just this young lady was in over her skis, ill-equipped to handle what was going on with this case. Kiana says there should be a screening or something to become a parent. Seeing so many cases of parents being awful to their children just makes me sad. I'm not sure how you would enforce that, though, Kiana. Kids tend to not be screened before they start having sex with people. In some cases, 10, 11, 12, 13, 14 years old, 8, 9 years old. In the cases of some extreme cases, oftentimes involving child abuse and, other things. Oftentimes when these children, they start having relations with other folks, nobody's screening them for their mental preparedness to become a parent, let alone be part of a co-parenting relationship where you're leading a relationship with, some boyfriend or husband or wife of your choosing. You're barely equipped to go to school. Jesus. Your life at 16, 17, 18 years old is to be doing all of the fun shit that you want to do while you're young enough to do it, because you don't know what you want to do and you're still trying to figure it all out. Your brain is still developing. You still got about another 10 years before your brain is fully developed. You probably haven't experienced a full spectrum of emotions yet. Love, hate, anger, confusion, success, failure, sacrifice, all of the things that make us adults. At what age would you say you were when you experienced all of them, the full spectrum of them? It's tough to say. So this young girl, Megan, I don't know, man. I don't know. It's human nature to hear these kinds of cases and to want to find somebody to blame. But knowing what I know as an attorney, I just feel like if we're going to put somebody away and convict them of murder, where we're subjecting them to life imprisonment without the possibility of parole, then you got to have stronger evidence than her fingerprints were on a trash bag that was used to dispose of her body. Oh, I wanted to run down her list of charges. I had this pulled up. Where did it go? I lost my notes. Well, give me a second, folks. Well, I had the thing pulled up, but that's fine. She was charged with, look, she's not going to be, it's not going to be a full-on acquittal. I mean, the question really is just, is she guilty of murder or not? I mean, that's the big one, right? Everything else is just kind of underlying charges. They've charged her with false reporting, obviously charged with felony murder, child abuse, child neglect, abuse of a corpse, multiple counts of such. They're seeking life imprisonment without possibility of parole. If you want me as a juror to lock somebody up away for life at the age that she is, you got to come with more evidence than that, man. I don't see it. I see an incomplete case. Well, my PC is not cooperating. All right. If I had to critique the defense's case, obviously they didn't really present much of a case of chief or a case in chief, if anything at all. They pointed to alternative causes of death, but they were unable to really pinpoint any threads that led that way. They focus on lack of definitive proof, but all they really did was raise the possibility. They suggested maybe SIDS was a thing, but there wasn't really any evidence or experts that came in to testify that was a genuine possibility. They talked about reflux. They talked about the rollover accident thing. They just failed to provide any concrete evidence supporting any of those alternative causes. Now, granted, they don't have to prove anything. It just would have been helpful if they could have at least brought in an expert to say that, look, there was nothing on Evelyn's body that we could point to that was definitive to suggest that this was a purposeful death. If you're asking me the question of what's the probability that she was murdered or that this was an accidental death, and take away the aspect that you found her in a trash can, obviously that's the strongest piece of the evidence, right? Because what they're rolling with is that Megan, if she did place her in the trash can, it was because of all these other things, but it wasn't because of murder, right? If they had an expert to get on there and say that, look, 50-50, it could have been accidental, it could have been homicide, who knows? I didn't see a definitive mark on that body, and I didn't see a definitive injury that pointed to asphyxiation by force, which is to lead me to believe that it could have been accidental. If we had a full autopsy, with a fresh body, could there possibly have been something? Yeah. But what we have is we don't have anything pointing at all towards that. I thought they depended, I don't want to say too heavily. It's kind of the only weapon they had in the bag. They had to depend on speculation regarding possible alternate suspects. For example, Hunter Wood was presented as a possible alternate suspect. Simply by suggesting, well, he had access to the property. He could have been involved in Evelyn's death. I guess in that case, so could the Amazon delivery guy. What is that? No evidence, far reaching. There's a danger in doing that. And okay, so you're saying that Hunter Wood could have been involved because he had access to the property? Could you give me something a little bit more concrete? What was his involvement? Because by all accounts, it seems to be that Megan was living the life of a single mom because Hunter was not involved in this child's life. What reason could he possibly have had to do this to a little girl like that? That would have been one, question the jury might have had. Obviously, Megan's failure to cooperate with law enforcement was rough. They didn't really have a good explanation for why she would do that. They're criticizing the prosecution's focus on Megan's behavior after Evelyn's death. But they still needed to offer some kind of credible explanation for the inconsistent statements and her actions. Even if it was just to say, hey, she's a stupid kid. What do you want from me? It's like the Better Call Saul argument in the very first episode of that season. If any of you guys watch that show, he's trying to defend these three co-defendants who were on trial for defiling a corpse or something like that. And they were on video, basically having penetrative sex with the eye hole of a decapitated skull or cadaver or something like that. And then what was Saul Goodman's explanation for why they didn't? They're 17, they're idiots. They're, something. He gave him something. He just said, the obvious, the very obvious, the Occam's razor. Why does she do it? I don't know. She's not the brightest. She's not the brightest crayon on the box. What do you want from me? Other than that, what else do I have? Over-reliance on reasonable doubt, but it was abundant. It was abundant. I don't see that big of a deal with that. But they didn't have a solid basis to challenge the expert's credibility or methodology that the prosecutors brought in to bring up the possibility that she died by asphyxiation. They were trying to suggest that data was incorrect, could lead to incorrect results, but it didn't really go anywhere. They didn't have their own experts, which is problematic. You tend to want to have your own experts if the prosecution is going to bring their experts, at the very least, to offer the possibility of alternate expert opinions for the same set of facts. That's a really easy way to create reasonable doubt. It wasn't a perfect case by the defense either. It was lacking. I think that if you had a more effective defense presentation, you would have had a longer case in chief. And I would have thought that the defense would have, in the 5 years, raised, maybe cost was a factor. Who knows? But I would have thought that if you're trying to present a competent defense, you would have had competing expert witnesses at the very least. Maybe you would have brought in a behavioral expert to analyze why Megan was so misleading with the police, in spite of the fact that she was innocent of the crimes being alleged, specifically murder. She was guilty of a lot of things. She wasn't guilty of murder, is my point. But they didn't do that. They did what they did. It was an over-reliance, somewhat on reasonable doubt. It was, look, when you have the opportunity to present evidence to a juror that points to alternate explanations that might stir the narrative towards not guilty in this case, you kind of want to do that. Maybe they tried, maybe they couldn't, maybe it was too costly. I don't know. But there is a danger in saying, oh, well, they didn't prove their case. They didn't prove their case, so we don't got to say anything. We're not going to say anything. We're not going to give you alternate reasons for why she did this and that, or why she didn't do this or that. We're just going to let it ride. Black 23. And let's see what happens. So it was not a masterclass in trial litigation on either side. It wasn't. It was a run-of-the-mill, average performance by the defense. There was nothing spectacular. There was not really many saving graces, if you're looking for saving graces, in the presentation of evidence on either side. I thought the prosecution was 5 years for that. where could they have proved? Where could they have improved? I think in the absence of that, I think you just got to think outside the box. I think maybe you bring in behavioral analysts, maybe to the extent that you could get those admitted into court. Now, generally, those are not, they're not admissible in court. But I would have, and you know, I haven't been following this case for 5 years. Maybe they did try to do something like that. The prosecution was really hamstrung by a lack of evidence. And what do you do? What do you do? There's two ways to take it. There, in the Casey Anthony test, in the Casey Anthony case, the reason that they failed was because there was an over-reliance on scientific evidence in a case that I thought went over the juror's head that was easily explainable by the defense, at least offering alternate theories. It was a gamble. And then they played the, oh, well, look at her. In the wake of her daughter's death, she's over here acting like a big whore. They went with the big whore prosecution, and it backfired. As a result, Casey Anthony, and there was a lot more evidence in the Casey Anthony case than there was in this one, was found not guilty. And the rest is history with that. Maybe I'll revisit that case. It's been a good couple years since I talked about it. But in this case, they kind of did the same thing. Look at her trying to live her best life, acting so indifferent and not caring that her daughter has been missing. Obviously, it's like in law school, you get in trouble for that. When you're writing papers, you just say, obviously, Megan is guilty because of X, Y, and Z, without giving supporting evidence that leads you to those conclusions. They're having these conclusory allegations based on speculation of what must have occurred based on behavior when we haven't even established a cause of death yet. That's problematic. They needed better experts. I don't know how they could have possibly remedied the lack of evidence in this case, but for have stronger experts. In the Casey Anthony case, I don't think they needed to go that far. I think they made mistakes for different reasons. I think in this case, I think that they just got, is it possible that they're going to get a conviction just because? Yeah, it is. I've seen jurors convict people in the absence of evidence before. I'm just saying, if I were a betting man, I'm going to bet on acquittal in this case. Casey says, I don't believe they had any foundation to bring in the opinion that Evelyn was left alone in the trailer. No witnesses to say they heard crying. Yeah, for sure. There was a lot of, I don't know, man. There was a lot of weird evidence that I thought they allowed to get in absent foundation. I think that maybe some of the reason why they did that, sometimes it's just, they're going to it's going to get in anyway. Let's just save the time and just let it in. Whatever. Fine. Casey continues, Megan being brought up in the volatile environment she was brought up in likely learned to lie and pretend everything was okay to keep the peace. That's exactly right, Casey. And that's kind of my point. I think that a lot of people can identify with knowing people that are brought up in volatile environments where they're brought up in an environment where it is normalized to lie and pretend like everything's okay when the mortgage hasn't been paid and the lights are off and the heat is off and the gas is off and the bill collectors are knocking and mommy's beating up dad or daddy's beating up mom and everybody's fighting and screaming at each other. And then they got to go to the Christmas Eve an hour later. And what do? You lie because it's what you do to save face. It's what you do to normalize. It's what you do to adjust to the temperature of outside forces that are exerting themselves on your internal universe inside the home. 100%. That is a viable explanation for what could have possibly possessed Megan to lie to law enforcement. I know that. And Casey, you seem to know that. And I guarantee you there's at least 4 or 5 or 6 or 8 or 11 or 12 jurors that could conceive of a similar premise. And that's the problem with the prosecution's case. They didn't do anything to take that argument away from the defense. Now, there's a couple of things. Why didn't the defense produce a bigger case in chief? One possible explanation was because the prosecution's case was so bad and so ripe with reasonable doubt, and they were in the room to read the jury. They get to watch the expressions of the jurors. They get to watch how they're reacting to certain pieces of evidence, certain pieces of testimony. It's possible that they thought that they had it in the bag, and when you're winning in court, you shut the F up, lest you make a mistake and return it the other way. Do I know that for sure? Of course not. Maybe that was the best. That was their preparation. I don't know. George is in the chat to say, glad to catch this live while I can't sleep. I watched every day of this trial. I believe she's guilty, but I think the state did a pretty terrible job of proving its case. George, I got to say, sometimes when you're the prosecution, you can't make up evidence, In the 5 years that they were prepping for this case, I got to imagine that they uncovered every possible conceivable stone to look for evidence that would support a conviction. And I'll tell you what, let me do you one better. When I was in the prosecutor's office, I was bothered by this idea that I have to win. I have to win my case. 97% conviction rate or whatever they say. You can't lose. If you lose in the DA's office, it's a big deal to lose your case. It's a big deal. It just bothered me because then it just created this environment where I did not want to win just for the sake of winning. They say, oh, how could you possibly defend somebody that is guilty? Well, how could you prosecute somebody that is innocent? How could you prosecute somebody that you can't prove the case? Now, look, there's prosecutorial discretion for sure. But oftentimes the prosecutors that are trying the case, it's not up to them whether or not they get to dismiss the case or not. They are told by their higher-ups whether or not they're going to take a case or not. The higher-ups are making the decisions about whether or not we're going to let this go or not. Sometimes you could, these small, but these higher profile cases that have garnered national attention, you don't just get those cases dismissed. Very rarely, because of political blowback, because of the bad publicity, because of whatever. It's very political. And I hated the idea of knowing that there were holes in the case, questions that I legitimately had about case regarding guilt or innocence of the person that I was prosecuting, and going to trial in a case like that with those doubts in mind. If I didn't believe in the case, I couldn't expect the jury to believe in the case. And I had no say in whether or not I got to go forward on a case or not. There was a very real moment where I was a law student. I was what they called a supervised intern, or I forgot what they call it, but it's one of these things where you get to make court appearances as an intern with the DA's office under the supervision of a DA. And so you would go there and you would argue motions and you would do trials and you would do stuff as if you were the attorney working on the case, but you're still in law school. It's kind of like an internship thing. And one of the first motions that I had to argue was a bail reduction hearing. And this defendant, he was accused back then. Marijuana was not legal yet. It was still very much a criminal thing to possess. And he had a long rap sheet of marijuana possession crimes dating back about 12 years. I mean, spaced out. It wasn't like one every year. Just like his first conviction was 12 years ago. He got one a couple years after that. And then he got another one, which would have been the most recent, which would have been 10 years after the prior one. So we had priors, but they were like petty, stupid misdemeanors that nobody would blink an eye at nowadays in 2025. He wanted a bail reduction so that he could afford his bail so that he can get out, because otherwise he wasn't going to be able to get out. And he had made an argument that he was involved in his daughter's special care. There was something that he was doing. I don't know if it was for autism or if it was some kind of other ailment that she had, but he was deeply involved in her medical care and wanting to continue to be a part of that. And the DA that was supervising me at the time, I remember they made this argument. It's like, yeah, sure, why not? What do I care? I mean, these crimes are not that serious. Misdemeanors, what the DA wanted me to argue was that, look, this guy's got a rap sheet going back 12 years. He's a career criminal. He's been in and out of jail for the last 12 years. He's been a danger to society for 12 years. And for all we know, Your Honor, he could be a danger to his daughter. And I just felt so icky, so disgusting making that argument. It just left a bad taste in my mouth. I didn't believe what I was saying. I could not in good conscience make that argument. I had to make it because Dia is standing right over me. But it just felt so shitty to do that. And I could see in a case like this, I can't blame the prosecution for putting on a weak case if the evidence is what it is. If they're not making up evidence, it's almost like, well, good on them for not like sensationalizing it, and trying to like make up or conjure evidence by way of these elaborate expert opinions that point to guilt where you wouldn't necessarily normally have that kind of testimony. And so you want to blame the prosecutor, fine. But in the case like this, I kind of am more pointing the finger at the evidence that they had to work with. It kind of is what it is with that. And so I can't, I respect. I mean, I don't know. I'm not in the mind of the DA in this case. I'm just saying, if I'm going to evaluate them fairly, I have to assume that the evidence that was presented was the best evidence that they had. And if the best evidence they had falls short of proving their case, I'm not going to hold them to account on that. I'll evaluate them on their presentation of evidence, on the way that they presented in front of the jury, on their oral arguments, on lots of things. But I'm not going to I'm not going to judge them on bad evidence because shit. I mean, defense attorneys got to do that all the time. They oftentimes have the worst of evidence. You just got to deal with it. And that's why defense attorneys tend to be way better litigators than prosecutors, because they're oftentimes, like 99% of the time, maybe not that high, like 90% of the time, the facts in your case are against you. And you got to come up with creative arguments, and you got to dig deeper than the prosecution has. You're starting at home plate. The prosecution starts on third base. Oh, look, here's all of the mountain of evidence based on the police reports, and everybody's saying that he did these things. Defense attorneys don't have that benefit. And so they go into the case and they do the best they can and then let the facts land where they may. And I think that the defense attorneys in this case were faced with this proposition that, hey, the prosecution's case is kind of weak. Maybe we don't have to do that much. And they responded accordingly. So I don't want to go out and say that the prosecutors are bad attorneys because of the evidence. I'm just going to say that if it was a weak case, you could blame a lot of people, but don't stop at the prosecutors. If there was other evidence to be had, blame law enforcement, blame the TBI, blame the FBI, blame CPS, blame all of these other people that could have accumulated evidence that would have led to a conviction, because if in fact Megan was responsible for the death of her daughter, that evidence did not manifest, did not land on the prosecutor's desk. And the prosecutors are not investigators. They can't make up the evidence. They can't go out and get the evidence. They're relying on their actual investigators who are tied to law enforcement, who are tied to other governmental agencies to put, look, you think, all right, you want me to charge him? I'll charge him. Now I need evidence. Get me all the stuff. If all the stuff they come back with is that's all they got, fingerprints on a trash bag, shit. And then they go and they talk to their peers. Hey, Dave, I don't know who Dave is. Let's just pretend Dave. Hey, Dave, the supervisor. I don't see how we're gonna get a conviction on this. I can't even point to a cause of death. I think that maybe we should amend the complaint. Maybe we should potentially take life off the table. Maybe we just make this a child abuse case. What do you think about that? We'll offer her, instead of a life without parole, maybe we'll offer her 25 years possibility of parole after 10. What do you think of that? And Dave says, yeah, you're We're not doing that. There's no way we're dismissing murder as an alleged count. Not when I got fingerprints on a trash bag. Sorry, bud. Do your best. I don't know if that's how exactly the conversation went, but I have personally had conversations with higher ups in the DA's office that went sort of like that. Sort of like that. How am I supposed to prove this case? Well, what about this? What about that? Look, and then they try to give you the whole pep talk. The judge is just the referee. They're not the ones that are going to decide this case. They're just calling balls and strikes. So you go out there and you put out the case and you let the jurors decide, and you sleep home. You go home and you sleep like a baby, knowing that you presented the evidence honestly. That's it. You believe in the justice system, you got to at least believe in that. And so you do. And so you do. And so, this case was not interesting because of the way that it was litigated. This case is, I don't know. I don't want to say that it's an interesting case. I just want to say that it's a compelling case. I'd rather say it's a compelling case because of the players involved. You got a 15-year-old beautiful little girl robbed of, her life experience was 15 months. What did she experience in 15 months? What environment did she grow up in? And what was she subjected to? What kind of happiness did she experience? What kind of pain did she experience as the product of a teenage pregnancy? Who knows, man? But it's never going to get better for her. I know that. You got the 17-year-old little girl that was tasked with keeping that child alive and raising her and doing all the things that parents do. And she didn't have any resources to do that effectively. So she did her best. Is she cold-blooded murder? I have no earthly idea. And you know what? Neither does the DA. And neither do her defense attorneys. If I were to take this case, it would have been my exact argument that this little girl is a lot of things, including kind of dumb, including inexperienced, including in over her head, including riddled with anxiety, including the victim of severe emotional trauma abuse throughout the years as a result of her own upbringing, including the mother of a 15-year-old baby, including the mother that was raising that child by herself. She's many things, and she's all the things that I just described, but you cannot tell me, and what the state will not be able to prove, is that she was a murderer. For the state to come in and try to argue that is a bridge too far. They don't have the evidence to suggest that. They're going to tell you that they do, but they don't, and they know it. And you're going to see at the end of this trial, there's going to be some evidence about my client giving inconsistent statements. There's going to be some evidence that suggests my client got scared, frightened, and might have maybe even hid the body, disposed of her in a trash can because of her overwhelming fear and anxiety. But you're not going to see a shred of physical evidence or circumstantial evidence that suggests my client was responsible for the death of that child, because it doesn't exist. You're not going to find a bruise. You're not going to find a strangulation mark. You're going to see that there will be an expert to come in and testify that this child died of asphyxiation. But you're also going to find out through cross-examination that there's more than 1,000 ways to die from asphyxiation, one of which can be murder, but which 999 other possible explanations don't include that. And what you're not going to find is any of those other explanations ruled out. Now, I might have had other thoughts about what other expert testimony to present to explain my client's behavior. I'm not sure if I would have needed it in this case, but that's how I would have approached it. I would have approached it sort of like that. And, that is not a unique defense position to take. There's, of all the famous trial attorneys out there in existence, of course, Clarence Darrow is the one that comes to mind. He's like the greatest defense attorney that ever was. Maybe the greatest attorney in American history, Clarence Darrow. There's also a guy named Jerry Spence, who was more famous for his work in civil litigation cases, but he humanizes these cases. He has a trial camp. In one of the, one of his tenements for trial attorneys, when you go to his camp to become a trial advocate, one of the things that he makes you do at his camp is, we're going to wake up in the morning. We're going to wake up at 6 a.m. and you're going to go about and you're going to, for an hour, be out there and hike on your own. And then you're going to come in front of everybody and you're going to sing us all the song, karaoke style. I want you to write me a poem. I want you to write me a sonnet. Sing a song. Act out a Shakespearean play. He is very big on humanizing these attorneys so that they're not so detached from human emotion and human empathy. Because in a jury trial, when you're trying to compel a jury to rule in your favor, all they have is not their legal expertise. They never went to law school. This might be the first time they've ever stepped foot in a courtroom. What they do have is a lifetime of human emotion that they can relate to. And the most effective trial attorneys are the ones that can take a case like this and spin a narrative that ingratiates the accused to the jury, where they can see, where it's plausible that this was a kid in over her head that found herself in a jackpot when she possibly rolled over in her sleep, exhausted after a 22-hour day, dealing with a child that was, I don't know, maybe the kid was sick that day, maybe it was irritable, maybe it was a lot of things, crying, and she's all by herself, and she's wake up in the morning operating off of 2 hours of sleep from the night before. She's been up since 4 a.m. and now it's 2 a.m. and she's exhausted and she could barely keep her eyes open, and she happens to fall asleep and lands on the baby. And unfortunately, in the most freak accidents, and obviously none of this came, and I'm telling a story at this point, but in a freak accident, she wakes up to find the lifeless body of little Evelyn underneath her. And in her panic, in her scramble, in her racing mind, doesn't think to call the authorities. She has no life experience. She's still in a position of life where she's afraid of the dark. When she goes down the stairs into a dark hallway, she still calls for her dad. And yet the prosecution wants you to believe that, there was only one possible way. She should have called 911 immediately. She should have known to administer CPR and do all of these things. Yeah, maybe, because if you're a 30-year-old adult, those things are all pretty simple. But for a scared kid who was the victim of a less than adequate upbringing, to put it lightly, to watch her navigate and expect her to navigate perfectly the way a reasonable adult would at 30 is a little unfair. And life is unfair. And I'm not asking you to excuse the bad things that she did do, because she did lie to the cops. She did do a lot of things. But what she didn't do is murder that child. If you can tell a story like that to the jury and they could cling to that, they will cling to that. The first jury trial that I ever did, it was back in 2016. It was in Riverside County. It was a criminal case. And it was a criminal case involving this kid. He was like 22 years old. And he had just gotten married, I think when the incident happened, it was literally his wedding day. And he was accused of assault and battery with a deadly weapon with the intent to commit great bodily injury. He was facing 12 years in prison if convicted on all counts. And I was going up against this prosecutor who he was like this vet. I was supposed to go up against this other prosecutor, but she was pregnant, and so therefore, and she was younger, a newer attorney. I felt reasonably competent or confident that I could at least hold my own. But then she gets called out because of medical reasons, and now I'm facing this other prosecutor who had like 20 years experience, and it was really intimidating. And I'm just like, at that time, I'd been practicing for maybe like a year and a half, maybe 2 years, and so it's like, fuck it. It was the most nerve-wracking thing I'd ever done. There was no sleep to be had. The set of facts went something like this. My client was getting married to his wife, and her ex-boyfriend kept on pestering her through text message and was saying derogatory things to her in text message. And so he took it upon himself to go and knock on that guy's door and confront him. And when he confronted him, a fight ensued. And my guy got in a couple of shots and cut the guy pretty good. I'm talking about like a fist. The guy was bleeding, had injuries. His brother, the victim's brother, there was 2 other individuals in the house that came chasing after him as he's trying to get away. He catches one of the brothers with a phantom right, and then he falls while he's in pursuit. The dad, who's like in his 50s, is chasing after him and falls and sustained injuries that way. And they claimed that he had brass knuckles. They claimed that he had a weapon. They claimed that they thought they were going to die and all this kind of stuff. And my client was so scared. I remember the trial took about a week. It took about a week. And on cross-examination, I just obliterated to shit these victims. From what I saw were very obvious lies. So there was a weapon. There was brass knuckles. Where was it? Where were these brass knuckles? Where did you find them? And what did you do? And I don't remember all the details I said, but my focus was on obliterating their credibility on the stand. And I got them to basically, the way that I won that case was because I got them to tell inconsistent statements on the stand. They basically changed their story from what they told law enforcement, and they lost credibility. And so we go into arrest our case in chief. We go into closing arguments. After closing arguments, jury goes into deliberations. And I told my client, look, from here on out, you got to stay 15 minutes within the court. You got to stick around. If they call you, they call you. You got to be here immediately. And when you're waiting for the verdict to come back from a jury, you're instructed, you got to be within 15 minutes at all times. So you're just kind of sitting there like a Starbucks or whatever. And they deliberated for a day and a half. And when they announced that they had a verdict, I was standing with my client. It was starting to hit him because either he was going to get acquitted or he's going to get sentenced to 12 years in jail. That was the way that he was thinking. I'm trying to console him. I'm trying to, at that point, there's no more to talk about. We already talked about what we thought about the case. We've already talked about what we thought about how we did, about the weaknesses, strengths, whatever. So at this point, there's nothing left to do. And the kid is just crying. He's like tears rolling down his face. And, I'm just like, I got my hand on his shoulder, like, hey, and I'm kind of freaking out myself. I'm nervous for him. And we get in there, and when we walk into the room and we're waiting for the jurors to come in, we're seated at the counsel table. The judge announces that the jury is allowed to come in. We stand up, we rise, we watch the jury come in. And I had spent a good week and a half with these people now. I was there picking the jury. I was there giving my opening statements, closing arguments to them. And, I've at this point, I feel like I know them by now. I know their facial expressions. I know how they react. I kind of get a sense for their sense of humor, how to make them laugh, how to get their attention, that kind of thing. And I remember as they were walking in, I don't think that she intended to do it, but there was this lady with blue hair, and she gave me it looked like a wink or like kind of like a nod, as if to say that, oh, you got this. I didn't know if that's what it meant at the time. But when the foreman read the charges, the jury finds in the complaint as it relates to count 1 that the defendant in this case is not guilty. Not guilty as to count 2, not guilty as to count 3, not guilty as to count 4. And we're like, holy shit. Oh, we won. And then me and my client, he gives me a big hug. The prosecutor, once everybody's dismissed, he just, hey, did a good job, man. Prior to that, after we had rested our case, we had a chance to go into chambers and just kind of talk to the judge. And what he told me was this, that it's always stuck with me. He's like, look, you didn't have a lot of experience and it showed. You're a newer attorney. You weren't going to measure up to this guy. He's been doing this for 20 years. But I'll tell you what, you have something. You have something. And what you have is you're like the everyman. You're like the guy that the jury at the end of a day of trial would want to go to the bar and have a beer with. And that means a lot. You're relatable. You could tell a story, you connect, and that means everything in these trials. Don't ever lose that. You're going to get better at the procedural stuff. You're going to get better at the mechanics of that. But don't ever lose the importance of connecting with the jury and being relatable. That stuck with me. Jerry Spence said a very similar thing. It's just that, look, and he was recounting a similar story about this. He remembers encountering this one attorney that was going up against these polished attorneys, like a team of attorneys. Like there was 3 people in their $800 suits, and they got their Rolex watches on, and they're representing the corporation. And this other guy, he's got this suit on. It's this boxy looking thing. The suit doesn't fit. His pants are wrinkled. His jacket looks like it's been sweated through. His hair is greasy and unkempt. The guy looks exhausted and he's tired. But when he spoke, the jury in that moment had to decide who they were going to trust. And they sure as hell weren't trusting those fucking people in their $800 suits and their fancy Rolex watches. They trusted that guy in the wrinkled suit because he connected with them and was more human to them than the other trio. And they trusted him and they believed him and he won his case. And if you want to be a trial lawyer, yeah, you got to be smart. Yes, you got to be able to think on your feet. Yes, you have to know the law. Yes, you have to have an immaculate knowledge of the facts in your case. But more important above all of that other stuff is you have to be human. Because if you're not human, you're already starting behind the 8 ball. And if the only thing you can do as a trial attorney is relate to the people that are going to be deciding the verdict in this case, then that is an extreme advantage that you should take advantage of. And I think that a lot of prosecutors lose that because they start with the evidence already in their favor like 97% of the time. Defense attorneys, they don't get to do that. They're always having to dig holes in cases, forcing them to be more creative. And that adversity that they're forced to endure causes them to have these bouts of creativity that lends itself to compelling arguments and humanizes them to a jury because they can see the hard work that this attorney has put into this case. And in conjunction with that, they can tell how much they care and believe in their client. And that's infectious. If you believe that your client is innocent, that rubs off on the jury. They can feel it. Even if they disagree with you, they'll feel it. If you hate your client, if you don't like your client, they'll feel that too. And so all that to say, I don't even know how I got on that rant, but I went on that rant. And all that to say with this case, with the little Miss Megan, I don't blame the prosecution for their lack of evidence. I respect their unwillingness to make things up and just present the case and just leave it up to the jury. You should find respect in that, because there's someone argue, well, if they had such a weak case, why didn't they just dismiss? Probably because the higher ups weren't going to let it happen because it was a high profile case, politics, whatever. But it is what it is. Megan Boswell, what do I think? What am I predicting? I'm predicting and not guilty, but I'm basing that off of my impression of the evidence. I would not be surprised for a guilty verdict, but I'm expecting a not guilty, at least on the murder charges in this case. Anyway, folks, I love you all. I can't believe I've almost been going for 2 hours. I was only supposed to do an hour show. Sometimes I get on these rants and I just go. It's also late. I love you folks. I will see you guys tomorrow. I got more stuff to talk about, just not tonight. You guys get some rest. I'm going to do the same. I love you all. Bye-bye.